All right, well, good morning, everyone. I'm Samara Zimmerly with the Worcester Chamber, and I want to thank you all for joining us. It's no doubt that this has been a challenging year for everyone, especially our business community. We've received a lot of calls and emails and questions coming from our chamber members here at the chamber, having questions about how to handle COVID in the workplace and that kind of thing, and that's why we decided to hold this event. So we want this to be interactive. So if you have questions, please hold on to those to the end. Once Kim finishes and gets to the question and answer section, feel free to unmute yourself and ask the questions. And we're really excited to have Kim Hall here, member with Critchfield and Johnston, and she's going to help walk us through some of the major COVID questions.
Perfect. Thank you, Samira, and welcome everybody. I know we are unfortunately still dealing with COVID-19, but it's worthwhile to provide everybody with a refresher on the federal law that is in place governing COVID-19 in the workplace, and to answer some questions you have about COVID-19, quarantine, and all things related to COVID-19 and employment. So I'm going to try and keep the presentation part of this as brief as possible to leave enough time for questions and answers, but I do think there's some important content we want to cover just to give everybody the backdrop for what we're dealing with with respect to COVID-19 in the workplace. And as I said, I'm not technologically savvy, so all right. So the federal law that I mentioned just now is the Families First Coronavirus Response Act. And this is what we're dealing with when we think about employees being out with COVID-19. Do we need to pay them? What do we pay them? This is the federal law at play. This law was passed on April 1st, 2020, and it's set to expire on December 31st, 2020. However, we still have a couple weeks before that happens, and right now, COVID-19 has really been spiking in our area, so it's more relevant than ever, and I've been getting quite a few questions from employers about the Families First Coronavirus Response Act because COVID-19 is starting to really impact workplaces locally. This federal law applies to all employers with fewer than 500 employees. There's two types of paid leave that are required under the law. There's paid sick leave, and then there's paid family leave. Now there are a few limited exemptions. One I'm going to get into later is what's called the small business exemption. Again, that's very limited, and there are some common misconceptions about the application of that small business exemption. So we're going to get into that here shortly. So again, there's two types of paid leave under the FFCRA. There's paid sick leave and paid family leave. Here on this slide, it shows the 6 qualifying reasons for paid sick leave under the Act. They're listed here. The first is the employee is subject to a federal, state, or local quarantine or isolation order. The employee has been advised by a healthcare provider to quarantine because of COVID-19. The employee is experiencing symptoms of COVID-19 and is seeking a medical diagnosis. There's two-part test there. They can't just be experiencing symptoms and want to stay home. They have to be actively seeking a medical diagnosis. Fourth, the employee is caring for an individual who is subject to a quarantine or isolation order or who has been advised to stay at home. Fifth, the employee is caring for a son or daughter whose school or place of care is closed or child care provider is unavailable due to COVID-19 precautions. And keep that reason in mind because that's also the qualifying reason for the paid family leave that we're going to get into later. The sixth qualifying reason here, that doesn't mean anything right now because the Secretary of Health and Human Services has not come out with a substantially similar condition. So that's sort of a placeholder right now. Okay, all employees, regardless of their tenure with the employer, again, an employer with fewer than 500 employees are eligible for the paid sick leave. So there's no hours of service requirement. For example, we know under the Family Medical Leave Act, there are certain requirements that are imposed on employees before they're eligible for FMLA. That is not at issue here. Rather, any employee, whether they're on day one of their employment with you, they're going to be eligible for the paid sick leave, provided that they meet one of the qualifying reasons we just went over. Okay, so how much paid sick leave can an employee get? An employee is eligible for up to 2 weeks max of paid sick leave and no more. Full-time employees, they get 80 hours at the regular rate of pay, subject to a cap of $511 per day for leave taken for their own personal health condition or because they have been advised to quarantine at home. And those are reasons 1 through 3 on the previous slide. Part-time employees are eligible to take the average number of hours they work over a 2-week period, subject to caps, and I have misplaced my cap on the slide. So the $511 per day cap, that applies to both part-time and full-time employees for reasons 1 through 3 on the previous slide. And then the $200 per day cap, that's also applicable to both part-time and full-time employees for reasons 4 to 6 on the previous slide. And those reasons, as you may recall, are if an employee needs to care for somebody who is subject to a quarantine or isolation order, or if the employee needs to care for a son or daughter whose school or is closed or child care provider is unavailable. Okay, so the second type of paid leave available under the FFCRA is the paid family leave. And that provides employees up to 12 weeks of leave for the one qualifying reason we mentioned earlier with respect to the paid sick leave. And that is if an employee is unable to work either at the place of business or work at home due to caring for the employee's son or daughter, because his child's school or place of care has been closed, or his or her child care provider is unavailable due to COVID-19 related reasons. So again, just one qualifying reason for the longer paid sick leave, the longer leave, the paid family leave, whereas for the paid sick leave, we saw there was those 6 qualifying reasons. Eligibility, unlike the paid sick leave provisions that kick in on day 1 of an employee's employment with a company, employees are only eligible for the paid family leave if they've been employed with the employer for at least 30 calendar days. And the paid family leave and the paid sick leave sort of work in tandem. Again, we saw that one of the qualifying reasons for paid sick leave is if you need to care for a child. And then we have the one qualifying reason for the paid family leave is if you need to care for the child. So if somebody needs to care for a child whose school is closed, the first 10 days may be unpaid unless the employee has that paid sick leave available. For example, if an employee is sick with COVID-19, takes 2 weeks of paid sick leave, and then later down the road, their child's school closes, so they need to care for that child, they no longer have that 2 weeks of paid sick leave available because they already exhausted it. So in that event, the first 10 days of the leave would be unpaid, and then the following 10 weeks of the paid family leave would be paid. However, if the employee does have their 2 weeks of paid sick leave available, they can fit that into the first 2 weeks. And so the first 2 weeks are paid pursuant to the paid sick leave provisions of the Act, and then the remaining 10 weeks are paid pursuant to the paid family leave provisions of the Act. And that leave is paid at 2/3 the employee's regular rate of pay, subject to the cap of $200 per day. And as I mentioned earlier, there is a very limited exemption to the FFCRA. There is a small business exemption that applies to employers with fewer than 50 employees, but it only applies for one qualifying reason, and that is if an employee is seeking leave due to the school or place of care closures or child care provider unavailability due to COVID-19 related reasons. So if an employee gets sick with COVID-19 and needs time off of work, the small business exemption is not going to apply.
Kim?
Sorry, I just had my phone ring. I apologize. So again, it only applies to one qualifying reason, and it is not automatic. So there's no blanket exemption to all employers with fewer than 50 employees. Rather, in order to claim this exemption, a authorized officer of the business has to be able to make the one of the following three findings. First, the provision of paid leave or expanded family and medical leave would result in the organization's expenses and financial obligations exceeding available business revenues and cause the organization to cease operating at a minimal capacity. Or to the absence of the employee or employees requesting paid sick leave or expanded family and medical leave would entail, I have another participant, would entail a substantial risk to the financial health or operational capabilities of the organization because of their specialized skills, knowledge of the business or responsibilities. Or three, there are not sufficient workers who are willing, able, and qualified and who will be available at the time and place needed to perform the labor or services provided by the employee or employees requesting the paid sick leave or expanded family leave. And these labor or services are needed for the organization to operate at a minimal capacity. So one of these three findings needs to be made in order for the employer to claim the small business exemption. You need to be doing this on a case-by-case basis. This is not something you should be announcing to employees ahead of time that you're not going to be offering the paid family leave or paid sick leave for that the need to care for the child. Rather, you need to address this on a case-by-case basis, depending on the employee who is requesting leave. There are a few other exemptions available under the FFCRA. There is a healthcare provider exemption and an emergency responder exemption. So those exemptions are a little more broad than, another participant, than the small business exemption, because these two exemptions here apply for any type of leave available under the FFCRA. So if you have an employee who is a healthcare provider or an emergency responder, you can apply this exemption, again, on a case-by-case basis for any type of paid leave under the FFCRA. So a healthcare provider includes what we typically think of a healthcare provider, a doctor, a nurse. It also includes people who perform diagnostic testing, but it doesn't broadly include anybody who happens to work at a hospital, for example. And on this slide, you'll see the examples of people who do not qualify for the healthcare provider exemption in the eyes of the Department of Labor. This is from Department of Labor guidance. It states that IT professionals, human resource personnel, cooks, for example, are not healthcare providers just because they work at a hospital or other healthcare facility. And the Department of Labor has also advised employers to be judicious with their application of this exemption What they don't want to happen is for an entire healthcare facility to say everybody in the building is exempt, and then there's a potential spread of COVID-19 because people may be coming into work symptomatic or sick, even though they're not supposed to be doing that. So the Department of Labor says be judicious with your application of any of these exemptions. Okay, so I have a couple FFCRA leave examples just to show you how the law is applied in some common scenarios I've seen pop up frequently over the last 8-9 months. First example, all employees have been exposed to COVID-19 at the work site. So the employer decides, okay, we're shutting down the entire work site for 14 days. Are those employees going to be eligible for paid leave under the FFCRA? No, they're not going to be eligible for paid leave under the FFCRA. Usually, when an employee has been exposed to COVID-19 and is advised by a healthcare provider or the health department, for example, to quarantine at home, they will be eligible for paid leave under the paid sick leave under the FFCRA. However, when the employer is the one advising employees to stay at home and there's no healthcare provider, health department that's advising the employee to stay at home, the employee is not going to be eligible for the paid sick leave under the FFCRA. Additionally, with respect to this example, when the work site is closed and work is not otherwise available to the employee is not going to be eligible for the paid sick leave. The work site needs to remain open and work needs to be available to the employee to perform in order for the employee to be eligible for the paid sick leave. Going on to our next example. All right, an employee is sick with COVID-19, gets a confirmed case of COVID-19, they're ill, and due to complications, that employee cannot return to work for a month. Is that employee going to be eligible for paid sick leave under the Act? Yes, of course, but they're only eligible for a maximum of 2 weeks of paid sick leave under the FFCRA. So what happens for the remaining amount of time because they're out for a month? If you're an employer with 50 or more employees, you need to consider the normal Family Medical Leave Act that existed before coronavirus happened and continues to exist. So that employee has a serious health condition that will most certainly qualify them for Family Medical Leave Act, which is unpaid. You also want to consider if the employee has paid time off available under the employer's policies to cover that remaining amount of time that isn't covered by the FFCRA. All right, third example. An employee has been exposed to COVID-19 but experiences no symptoms. His doctor advises him to quarantine for 14 days. Is he going to be eligible for FFCRA sick leave? Yes, he's eligible for up to 2 weeks of paid sick leave because the doctor has advised him to quarantine at home. All right, so looking forward, as I mentioned at the beginning of this presentation, the FFCRA is set to expire on December 31st, 2020. Questions, is Congress going to extend the act? If not, what happens to employees who get sick with COVID-19 or have one of those qualifying reasons for paid sick leave or paid family leave? But what do they do? Employers will want to consider potentially modifying temporarily their PTO or sick leave policies. Maybe you want to offer some additional sick days to employees so they have some paid time off available to them in the event they get sick. As I mentioned previously, the FMLA still continues to apply to employers who are covered by the FMLA. And then you also want to consider the Americans with Disabilities Act. If an employee has an underlying health condition that qualifies as a disability, for example, if an employee has cancer and they're receiving chemotherapy, you always need to be keeping in mind what accommodations you may need to provide to that employee as a reasonable accommodation for their disability. So there's a lot of different federal laws floating around there that come into play with respect to COVID-19 employees with medical conditions or employees who get sick with COVID-19. Okay, so this is a new update. I think it was this past week, the CDC updated its quarantine guidelines. They've trimmed them down a little bit. Previously, an individual who was exposed to somebody with a confirmed case of COVID-19 was advised to quarantine at home for a period of 14 days. Before I get into the modified quarantine guidelines, so first want to go over the definition of exposed. So what does exposed mean? Exposed means somebody was within 6 feet of a COVID-19 positive person for a total of 15 minutes or more in the period beginning 2 days before the symptom onset until that COVID-19 person returns from quarantine. So if I'm around a coworker today, we're driving in a car for an hour, and 2 days from now, my coworker starts experiencing symptoms of COVID-19 and gets a positive COVID-19 test, I have been exposed to somebody within the meaning of the CDC guidelines. Okay, so as I mentioned before, previously, if somebody was exposed to COVID-19, the CDC says you need to quarantine at home for 14 days. This past week, the CDC says, or you can quarantine for 10 days without getting a COVID-19 test if you don't develop symptoms during that 10-day period of time. Or you can really trim it down to 7 days if you don't experience any symptoms of COVID-19 within those 7 days, and you get a negative test 48 hours before you're planning on ending your quarantine. So that can be helpful for employers who may have an exposure at the work site and they're potentially facing employees having to quarantine for an extended period of time. If those employees go out and get the negative COVID-19 test and don't develop symptoms, they can be back to work and have that period of time. Okay, well, another thing to think about going forward, since we have these vaccines that are coming out, we've just seen in the UK that vaccinated some folks over there. We have received the question of, should we as employers mandate that employees get the COVID-19 vaccine? Right now, it's a little too early to tell if that's a good idea. The Equal Employment Opportunity Commission has come out with a statement saying mandating vaccines under these circumstances, this is unprecedented. We've seen healthcare providers mandate the flu vaccine, for example, but the difference here is the vaccine is still, vaccine for COVID-19 is still under an emergency use authorization. Once the vaccine receives full government approval, the EEOC feels a little more comfortable about employers mandating the vaccine. But again, this is unprecedented and we've never dealt with a situation like this before. So for now, tread with caution, wait to see if the government provides the full approval for the vaccine, and then we'll be in a little safer situation to consider mandating the vaccine for employees. But aside from the legal aspect of this, you also have the employee relation aspect of how are employees going to react if you require them to get a vaccine. I can imagine in many workplaces that would not necessarily be received well, so that's certainly something you would want to consider before mandating any type of vaccination for your employees. Going forward, what should you be doing now to help protect your business and your employees in this very difficult environment of COVID-19 that has been going on for quite some time and will likely continue on for some time until we're able to get more folks vaccinated? Be proactive. Think about your employment policies, your PTO policies. Do you need to consider modifying your PTO policies temporarily to allow employees more PTO days? Do you need to consider allowing employees more flexibility with respect to work schedule? One important thing is, like I mentioned earlier, the FFCRA is set to expire on December 31st. If that act does not renew, if Congress doesn't renew it, and if you have an exposure at your work site, you could potentially have a number of employees who have to quarantine at home without pay. How are you going to deal with that type of situation? One thing you want to do is you want to ensure that there is no exposure at your workplace that could potentially affect all employees. For example, if you have employees who are working in very close contact with each other, maybe they're not practicing social distancing and they're all mingling together. If one employee gets sick and the health department does contact tracing and they find out that everybody in the work site has been exposed, that you could be ordered by the health department to have your entire employee base quarantined at home, and that's going to shut down your business operations. So you want to make sure that if there is an exposure at your workplace, that not all employees are going to be exposed within the meaning of the CDC's guidelines. So maybe having employees work alternating schedules, really ensuring the social distancing, mask wearing, that's going to be helpful in preventing a entire workplace shutdown if somebody does get sick with COVID-19. All right, so I wanted to leave enough time for questions. So happy to take any questions you might have. Nobody? Come on, I know you have questions.
We had a couple.
Hey, Kim, it's Seth.
Go ahead, Seth.
I emailed it back. I suppose I can ask it. Kim, it's Seth Buckwalder over at Whitaker Myers. How do we handle allowing people to work from home? We've noticed a little bit of a disparity. We've had to send some folks home due to underlying health conditions. Is that something that, if we have the technology to enable, that we are then required to allow any employee for any reason to work from home for any length of time? Or how do we handle that?
So for the employees who have the underlying health condition, we want to look back at the Americans with Disabilities Act, because remote work or working from home could be required as a reasonable accommodation for their disability if it allows them to perform the essential functions of their job. So with folks who have the underlying medical condition, remote work may be something that the employer is required to provide to them. But for folks who don't have any underlying medical condition, you as the employer are not required to allow them to work remotely. So that's something that's not mandated by the law. If employees are able to perform the essential functions of their job while working remotely, it might be something you want to consider providing to them if they would otherwise be unavailable to work. For example, if they have one of those qualifying reasons for paid sick leave, if they have a child whose school is closed and the parent therefore needs to be at home to care for the child, if you can provide remote work to that employee, then you're not going to have to pay that employee paid sick leave, because the paid family leave and the paid sick leave are only available if the employee cannot work at the work site or perform remote work at home. But it's not something you're obligated to provide employees who don't have an underlying medical condition.
Thanks.
You're welcome. And I believe Samir sent me some questions about testing and when people can return to being around other folks after they've either tested positive for COVID-19 and have been symptomatic or have been asymptomatic. So I'll just go over some of those requirements from the CDC. So if somebody has symptoms, you can be around others after 10 days since the symptoms first appeared and 24 hours with no fever without the use of fever-reducing medications and other symptoms are improving. So those are the CDC's current guidelines for people who had symptoms. For folks who tested positive for COVID-19 but did not have any symptoms, you can be with others after 10 days have passed since you had a positive viral test for COVID-19. So those are the current CDC's guidelines for returning to be around others after you've had COVID-19. And I would encourage you as employers to check the CDC's website relatively regularly, because the CDC does update their guidance, and they have pretty user-friendly website with some helpful information. So for example, a couple weeks from now, the information on quarantine guidelines that I've given you today may be updated. So it's worthwhile to take a look at the CDC's website to get up-to-date information. Other questions?
Hi, Kim. This is Lubar. I have a question or two.
Yes, go ahead.
My first question is, if we send an employee home because of high temperature, and we did not hear anything from the medical provider, doctor or something, do we need to pay that employee? And at the same, on the same matter, if an employee said he was exposed, we did not have any word from the doctor, do we have to pay him, or how we handle those two situations? The last question is, or if you want to answer and I ask the last question.
Sure. Yeah, if I can go with the first two questions, then we can move on to your third one. For the employee who has a high temperature and you send him home, if he is not going to go out and get a COVID-19 test, or if he doesn't speak to his doctor in the meantime and the doctor says, hey, you need to stay home from work, then you don't need to pay that employee under the FFCRA. For the employee who informed you that he was exposed to COVID-19, but he doesn't tell you that the health department has advised him to stay at home, or his healthcare provider hasn't advised him to stay at home, then you don't need to provide him with paid sick leave under the FFCRA. However, if he develops symptoms of COVID-19 in the meantime, and he goes out and is seeking a test for COVID-19, then at that point he would be eligible for the paid sick leave. But if he just says, I was exposed and I am staying home without any additional information, that is not going to qualify him for the paid sick leave.
Okay, maybe I will add another question, sorry. Because
yeah, no problem.
Lately, we have been struggling with the health department because they cannot reply to our email for confirmation soon, and then we have in between the payroll. So we don't know what we do because we do not have confirmation, but they went to see the doctor. We don't know if they are quarantined or not. So we in that dilemma now what to do, right? And the healthcare center has a backlog. It will tell us we get back to you in 2 days, 3 days. So, and then we have payroll in between. How we handle that?
So if the employee is saying that the health department advised them on the phone to quarantine at home, or they spoke with their doctor on the phone and the doctor says stay at home, you're able to take the employee's word for it and pay them the paid sick leave based on what the employee communicated to you. You're not required to have an actual written letter from the health department saying the employee has to quarantine in order for the employee to be eligible for the paid sick leave. But if the employee is just at home and is waiting to hear back from the health department, but hasn't been advised verbally and writing or otherwise by the health department or the doctor to stay at home, then the employee is not going to be eligible for the paid sick leave until we get word from the doctor or the health department that they should be quarantined at home. You may be able to sort of retroactively pay them for the period of time they were off. If the health department, for example, gets back to the employee 3 days later and says, yeah, you were supposed to be under quarantine for 3 days and you need to be under quarantine for 2 more days as well, then you can retroactively pay that employee the paid sick leave once you do get word from the health department. But until you have that confirmation that the employee says, yes, I have been advised to quarantine at home, then your obligation to pay them the FFCRA sick leave is not triggered yet.
My last one, sorry, is can we force an employee who's saying he has or she has pre-existing condition, can we force him to come work in the office when we do not mandate wearing mask in the office? Can we force somebody who's saying, I have pre-existing condition to come work in the office?
To come work if they're not wearing a mask?
If there is no policy to mandate mask in the office, can we ask an employee who has pre-existing condition to go work in the office?
So for the employee who has the underlying condition, we would want to tread lightly on requiring them to come to work without first discussing what possible accommodations we may need to provide to the employee. If the employee's physician says this employee would be at significant risk if they came to the office right now due to their disability, and I, as a physician, am recommending a 2-week period of unpaid leave as a reasonable accommodation for a disability, you would want to engage in the interactive process with that employee to decide if a brief period of unpaid leave would be required as a reasonable disability. So that's something you would want to address on a case-by-case basis by engaging in the interactive dialogue with the employee.
Thank you.
You're welcome. Any other questions?
Yes, I have a question, follow-up about mask wearing. If we have employees that refuse to wear a mask, but have not provided any kind of medical documentation, is it reasonable then if they can work remotely from home just to require them to do that and not enter our place of business?
Yeah, that would be a way to deal with that type of situation. If the employee is able to adequately perform their work at home, then that sounds like a good resolution for everybody involved. If remote work is not available to that employee and they're just refusing to comply with the mask policy and don't have that underlying health condition, then you're able to discipline them. Ideally, we would be able to provide them with remote work and not have to go through the disciplinary process, but an employee is not able to just refuse to comply with your company policies without a medical reason as to they can't wear a mask. But providing remote work to the employee if they are able to adequately perform their job at home, that sounds like a good resolution for everybody involved.
Thank you. And then it's appropriate to ask for documentation from their medical provider, correct? If they maintain that they do have a medical condition, but have not provided documentation to that effect.
That's correct. So if an employee is seeking an accommodation for a medical condition, you're able to get documentation substantiating the nature of the condition and the functional limitations that it imposes on the employee, and then the need for the accommodation. So that's something you can request of the employee if the need for the accommodation is not completely obvious to the employer. But you are able to request that information to
Thank you.
analyze whether the accommodation is reasonable or necessary.
Kim, one of the questions that was sent in is how long is a business required to close if an employee tests positive?
Yes, so this may depend on the location where you are and how many employees have been exposed. So the primary thing you want to do is work with the health department. If the health department is telling you we have done contact tracing and we have determined that every one of your employees in your work site has been exposed, then they're likely going to require you to shut down and have employees quarantine for 14 days. However, you can have employees return prior to that time if they're asymptomatic within 10 days, as I went over previously. But there is no law saying if somebody is sick at your work site, you have to close down. There's no law. Rather, we're looking at the local health departments. What are they advising employers to do? And really, there shouldn't be a required shutdown period of time if your entire workforce has not been exposed. If you just have one individual who may have exposed another coworker, but nobody else in the office has been exposed, it'd be ideal for you to shut down to do some deep cleaning, but you really wouldn't need to be shutting down for 14 days because you've ensured the social distancing and made sure that there's no exposure to your workforce at large. So if somebody is telling you need to shut down for 14 days, yet there's no broad exposure of your employees, that would probably be something you'd want to ask a couple questions of the health department. Why are we having to shut down for 14 days? We've been really good about keeping social distancing, gather a couple more facts, but work together with the health department to see what they're advising you to do.
Does anyone have any other questions? Okay. Kim, thank you so much for taking the time to present to us today. I know this information is going to be helpful to a lot of people, so we appreciate it.
Yeah, you're welcome. Glad to see you all today, and I hope this was helpful for you all, and hopefully we won't have to do a repeat of this in another 6 months.
Let's hope not. Thank you,
I hope this is the
everyone,
grand finale.
Yes. Thank you for joining us and have a great day.
Thanks, everybody.